only conflict we see is this: where's my truck? I heard you stole the engine or sold the engine out of my truck. Where's my truck? I heard you sold the engine out of my truck. And for that, this guy massacres 3 young men, 23, 27, and 30, on their way fishing Friday night near Frostproof. It's gut-wrenching. This is evil in the flesh. This is a guy who can hurt you just because it's the right thing for him to do at that moment in time with his 3 brain cells.
And that's where we begin, with the triple homicide out of Frostproof, Polk County, Florida. Welcome to Law&Crime Now, everybody. I'm Jesse Weber, and thanks for joining us. We are learning new details from the arrest affidavits in this case, including the autopsy results of the 3 victims. Now, the 3 assailants who have been charged with this massacre are Tony T.J. Wiggins, his brother Robert, and TJ's girlfriend, Mary Whitmore. I want to break down everything with Law&Crime legal analysts Imran Ansari and Terry Austin. It's great to have you both here. Imran, I'd like to start with you. Let's talk about the autopsy, okay? So all 3 victims were shot multiple times. If we actually go through it really quickly, Brandon Rollins, so 1 bullet hits his left shoulder, another bullet hits near his left collarbone, a third his right forearm and actually hits the fingertips, and a projectile was found in his lower back. Kevin Springfield shot in the neck, shot in the head. Damian Tillman shot 3 times in the chest and once in the right arm. Now, obviously, this is horrific and quite brutal, but what does this tell you about what went down on that day? And maybe more importantly, how can the prosecution and the defense both use these autopsy results to tell their stories?
The connection I have right now is not optimal, but I think I heard your question. I mean, the autopsy reports really show a brutal crime here. I mean, you have multiple gunshot wounds to these victims, and I think the prosecution is going to be able to really use the evidence to bolster their case.
And Terry, I'll jump to you. What about the defense? You know, if we're talking about a situation why this happened, and if you read the chat rooms, people are very confused as to the motive here. This was over an allegation, an accusation that one of the victims stole TJ Wiggins, or sold his truck engine. So people are maybe wondering, well, what led to this? So if a defense is going to go forward with, hey, listen, this was a conflict, it broke out, he was acting in self-defense, and I know you don't have an expertise in crime scene analysis, but listening to this, how could the defense utilize the findings of the autopsy?
Well, listen, Jesse, from a legal perspective, I think the defense is going to have a very difficult time. That crime scene was horrendous. 9 rounds went off altogether. 1 was shot twice, 3 times, 4 times for the other 2. That's a lot of bullets going off. It's hard to say that it was in self-defense. It's hard to say that there wasn't a motive here. You know, I don't know what they're going to say. It's a very difficult case for the defense. The only thing they can say, it wasn't me, but they have one of the brothers saying, yeah, it was us. So, you know, I think they're going to have a very hard time. I think the prosecution has a very strong case.
I'm glad you mentioned that. I'm glad you mentioned that because, again, as I said, we're learning more details from the arrest affidavits. Robert seems to be the one who's cooperating with police, and apparently, according to him, he tried to stop his brother TJ once the first shot was fired. What do you make of that?
Well, he didn't stop soon enough. There's some conflicting information here as far as I'm concerned. I saw one report that said that he tried to stop his brother. The other report said he got out of the car after all of the shooting had ceased. So if he was really trying to stop him, he should have stopped him before he got out of the car and said, what are you doing? Why do you have that gun? What's your plan? And tried to make sure that people weren't getting killed here. So, you know, a little bit too late and a little bit too little effort here to stop his brother from basically mass shooting 3 individuals.
Well, let's go into a little bit more of the story that's been laid out by authorities. If we go back to Sheriff Grady Judd in this case, when he explained the story in the press conference, first he's going to talk about, as you'll see, how this precipitated all from a meeting at a convenience store, the Dollar General store, and how basically one of the victims said that he was going to meet the other victims, and apparently one of the assailants overheard this, and that's when everything went down. Take a listen.
So our detectives now confirm that, hey, this guy Tony or TJ that we've received tips from is standing in line with and had a conversation with Damien in the store. We don't have the conversation because there's no audio, but from body language, it was not violent or animated. It was just a normal conversation. But our detectives on Monday found our suspects, and they were living on Sarver Avenue in a family compound of camper trailers, and this is in the woods outside of Frostproof, and they were living off the grid. No running water, no electricity. They had some generators. So understand that now we're talking about Frostproof in a rural part of the county. The shooting happened in a rural part of the county, and we literally have to walk the road, and we go down a dirt path through the woods that opens up into a compound off the grid.
So now we get a sense about why TJ Wiggins ultimately tracked these individuals over, again, a truck engine, overheard them being there at the store and where they were going to go next. You also heard about the assailants living off the grid. That's important because in an earlier show, we mentioned that there were 4 new arrests in this case, including the father and uncle of the Wiggins brothers, who were picked up at this compound where everybody lived, and they were charged ultimately with environmental offenses. Okay, keeping all that in mind, we're going to go back to the sheriff, and here's where he lays out who's cooperating right now with authorities and also the ballistics evidence in this case, how it ties to the Wiggins and Miss Whitmore. Take a look.
So our detectives immediately interview Tony Wiggins and Robert and Mary Whitmore. Robert and Mary consistently lie to protect TJ. Robert lies to us, Mary lies to us, TJ lies to us. They don't tell us the truth. The only common thread during their interviews, otherwise the stories are all over the place, from different vehicles to where they went to they didn't go any place, but they agreed on one thing. They went to McDonald's and ordered 10 double cheeseburgers and 2 McChicken sandwiches. That's the only thing. So on Monday, we executed a search warrant at the compound. TJ was found to be in possession of 2 shotguns and 2 SKS 7.62 rifles. He's a convicted felon. He can't possess firearms, so he was immediately arrested. Our forensic investigations team found 1 9mm shell casing, 1 at TJ's trailer. The Florida Department of Law Enforcement said from the very beginning, I had 2 conversations with the commissioner this weekend. He's a dear friend of mine. He said, Grady, FDLE's here to do anything you need. And I told you about them chipping in $10,000 to help. And he says, our lab's at your disposal. I called him Monday afternoon. I said, we need to compare some shell casings from the scene to a shell casing at our prime suspect's house. We planned to bring it over in the morning. He said, no, bring it over tonight, and let's get started. They brought in people. That's the help. That's the teamwork. What did we determine? The shell casing at the scene, the shell casing at TJ's house were all fired from a Smith & Wesson handgun. And both the shell casing at home and at the scene were fired from the same weapon, the weapon that committed the massacre, in the hands of TJ.
All right, Terry, back to you. As you can hear, there's some strong evidence that are laid out against these three. But we're in a weird situation. A new update in this case is that COVID-19 means that we might not have a grand jury to formally indict these three people anytime soon. And I find that to be curious because people might be looking at this and say, wait a second, they're arrested, they're charged. What about, why do you need a grand jury indictment? And number two, is it right that they're locked up without a grand jury indictment? I mean, we are living in interesting times, but do they have a constitutional right here at any point? So how do you think about the lack of an indictment at this point?
Well, you know, they definitely should have a constitutional right to a speedy trial and to be indicted. And I don't think they need a grand jury here. They have probable cause. They have all of the evidence they need to not only, you know, make the arrest, bring the charges and the indictment, but they could proceed forward if, you know, obviously COVID-19 is making it a lot more difficult to have hearings and court proceedings. But I think that they have enough without the need to bring the grand jury to bring the indictment. We are in Florida here, so I think they could proceed a bit faster than what they're doing.
And my understanding is in Florida, for these serious offenses, you actually are required to have a grand jury indictment. And let's not forget, we're dealing with a situation with TJ Wiggins where he is charged 3 counts of first-degree murder, which begs the question, could the death penalty be on the table? Will prosecution ultimately go for that? And that's the question here, because that's what the grand jury indictment would say, correct, Terry? They need to ultimately list that out in an indictment.
Absolutely. And, you know, Florida isn't hesitant to actually use the death penalty. They're one of the few states of 30 states who have the death penalty to actually use it. They had one not that long ago, I think in 2019. So, you know, to your point, if they wanted to bring the grand jury and actually indict these individuals, they could do that. I mean, we've been seeing in other states and other trials the fact that they have these Zoom hearings, et cetera. I think they could do that here, particularly since we know that, at least as far as TJ is concerned, he should be in jail behind bars because he clearly shouldn't be out and allowed to commit additional crimes.
And you don't usually see, and thankfully you don't usually see this kind of massacre, but COVID-19 is creating complications in the whole legal system. We're going to obviously focus on this case as it continues, but when we come back, more updates for you in Ghislaine, Maxwell, and Harvey Weinstein. Stay tuned.
The goal of going after me was to get a lot of money from Leslie Wexner, who was accused of the same thing. They accused me publicly, and then they accused Wexner privately in an attempt to get some money from him. But and the best friend told me that Virginia Roberts told her she was, quote, she felt pressured to include me, even though she had never previously mentioned me as one of the people with whom she allegedly had relations. So my case is completely closed over. I've been completely cleared. I had nothing to do with it and never met the woman. And this is a woman who should be seriously punished for having submitted false information and a false affidavit.
But now we might get a chance to learn even more because a judge has officially ordered the immediate release of once secret documents from a now settled lawsuit against Jeffrey Epstein and Ghislaine Maxwell, these purported accomplices in a sex trafficking ring. Now, the question is, what are in these documents? Well, one is apparently a deposition from the man you just saw there, Alan Dershowitz, and he has adamantly denied any allegations that he sexually abused anyone, including minors. I want to bring back on Law&Crime legal analyst Imran Ansari, as well as Terry Austin. Now, Imran, you actually represent Mr. Dershowitz. So if you can, my understanding is he has been almost encouraging these documents to be released, encouraging this deposition to be released. And correct me if I'm wrong, but if that's the case, what can we expect if this deposition does become public? And I'll warn our viewers right now, I understand you might be limited in what you can tell us.
Right, Jesse. So yes, I represent Professor Alan Dershowitz in both the Giuffre v. Dershowitz matter in the SDNY, and also the Giuffre v. Maxwell case. We have put an entrance into that matter as an intervener on behalf of my client, Professor Dershowitz. So as you heard from Professor Dershowitz himself, he has been advocating and pushing for the release of these materials in the Giuffre v. Maxwell case for quite some time now. So we're pleased with this decision. We're pleased that certain documents in the Maxwell case will be released, because my client, as he has stated himself many times, he has nothing to hide. He wants this material out there. He feels that it's going to vindicate him, and we're confident that the materials, once they're released, will support his defense and also his counterclaims against Virginia Giuffre.
What about the correspondence between Epstein and Maxwell? We believe that is a part of this document release as well. And people have suspected, are they mentioning high-profile individuals? There's a reason she might not want this out there.
I think we're going to have to wait until those materials are released. Judge Preska has ordered those materials released. There is an attempt to stay the decision, but as we see in her decision from Tuesday, we expect those materials to be released and in full compliance with her decision. But I think we're going to have to wait until those materials are actually made public before any comment is made on those materials specifically.
Imran, I'm glad you mentioned that, because her attorneys, Maxwell's attorneys, have filed a letter with Judge Preska. I'd like to put up a portion of it. This is actually just the beginning of it. And the goal is to try to prevent the deposition of Maxwell from being revealed, or at the very least, as you said, allow a stay in order to appeal to the Second Circuit. And as you can see here, their argument is that this deposition was in a civil matter. It was supposed to be sealed. The only parties to the litigation, were the only ones who were supposed to actually know about it, and that ultimately it's wrong for the government to rely on this as a form of or basis of the perjury charges, and that they say this is a violation of the protective order. So, Terry, I'd like to turn to you. The idea that Maxwell relied on this protective order, relied on this confidentiality to be so forthcoming in what she disclosed in this civil deposition, now it's being used against her in a criminal matter. Is there weight to that? How should the judge rule? Should the judge ultimately allow a stay of the deposition being released to allow a higher court to rule on this?
Well, look, I think that when you have an agreement and you proceed forward and the parties all have one understanding that the documents will be sealed, I think that should carry some weight. We see that in some instances in another proceeding, whether it's a subsequent civil proceeding or whether it's a subsequent criminal proceeding, judges have allowed these prior proceedings to come into evidence. And, they are weighing what we always know, the probative against the prejudicial value here. But I do think there's more in this case, and Maxwell has a decent argument because they had this agreement to keep the information confidential, to keep it under seal. So there's an argument both ways, but, we'll see what the judge does at the end of the day.
Well, we have time. I'd like to move from one high-profile and celebrity-infused sexual assault case to another. Let's move over to Harvey Weinstein, because we discussed on this program how the proposed multi-million-dollar settlement that would have set up a compensation fund for Weinstein's alleged victims, that was ultimately rejected by a judge. Judge said it was completely unfair. Now, having said that, the New York Attorney General, Letitia James, is being heavily criticized for approving the settlement because they said that her allegations are out there that she made false promises, that this settlement included terms that she said she would never have agreed to. And just to give you an idea, that she's accused of saying that there wouldn't be a payout to Weinstein in any way, yet this proposed settlement created a fund, a defense fund for him and his co-defendants to pay their legal fees. Also, she's been criticized for not being transparent about how the settlement would ultimately affect accusers' right to recover monetarily. And so when we see this, and Douglas Wigdor, who represents about 6 purported victims in this case, he's been critical of this settlement from the very beginning, critical of the New York Attorney General as well. Let's just listen to him. I think this is all the way back from when Harvey Weinstein had his criminal trial. This is him speaking about a purported settlement. Take a listen.
And I would be remiss, though, if I did not talk about the purported and alleged settlement that's been in the news over the last few weeks, because that settlement is one of the worst civil settlements that I've ever seen. It is a one-sided civil settlement, and my 2 clients, Waddell David and Kaya Sokolow, as well as many other women who have contacted me in the last few weeks, will be vigorously objecting to that civil settlement. It's the only civil settlement that I've seen that pays $12 million to the director defendants who we allege were part of the scheme to enable Harvey Weinstein. There are also millions of dollars going to class counsel. There are also millions of dollars going to vendors, secured creditors. And to make matters even worse, to the people who want to opt out of the civil settlement, they are trying to bind them by providing releases to the insurance companies and providing releases to the directors. And my biggest surprise, frankly, is that the Attorney General, the former public advocate, is not standing with me shoulder to shoulder in denouncing the civil settlement and making sure that Harvey Weinstein is held accountable not only in this courthouse for his criminal wrongdoing, but in the civil courthouse for the civil wrongs he committed.
All right, Imran, I'd like to turn to you. You represent Mr. Weinstein in the civil arena, and we've talked about this settlement before, but I'd like your opinion and what you can say about the criticism of the Attorney General, that she made false promises. What is your take on those accusations?
Well, listen, Jesse, this settlement was negotiated between the defendants, the AG, and the plaintiffs. I think it's being lost in the public voice and the public perception of this settlement that the plaintiffs themselves negotiated and wanted this settlement to happen. Now, it's easy to yell loudly and criticize this agreement, but it's also putting aside the very fact that the Weinstein Company is bankrupt. My client, Harvey Weinstein, is not in sound financial health. He's incarcerated. He is facing debt. He has obligations financially that he has to take care of, both legally and for other matters. And essentially, this settlement, in my opinion, was the best route for recovery for these people who have made these accusations. Now, I think it's being lost in the public perception. I think that the certain voices are screaming loudly. They're railing against this settlement. But in the end, what will be left to recover for the individuals who have these claims? With a bankrupt company, with an incarcerated defendant,
well,
this settlement
your
may be the best route to
actually
recovery.
echo the statement from the Attorney General's office. I mean, the statement said the same thing. Without a comprehensive settlement in this case, dozens of Weinstein survivors will be left with nothing. But I'd like to ask you about this, because it's come out that apparently an attorney for the Weinstein Company is trying to have a Delaware bankruptcy court approve a settlement, a far-reaching settlement in this case. And Douglas Wigdor has come out again and has said that what they're trying to do here is just circumvent Judge Hellerstein's order. That if you can't get Judge Hellerstein to approve a settlement, that they have now gone to a different court, a Delaware court, to try to get it approved there. What do you say to that critique?
Yeah, I wouldn't really call it circumventing Judge Hellerstein's order. It's really Judge Hellerstein did not approve the settlement. He disagreed if it was in fact a class action, and now those involved, the defendants, the attorneys for the defendants, the attorneys for the plaintiffs, the insurers, the AG's office, going back to the drawing board, right, and going back and trying to rework this settlement to a point where it will be approved. Because again, A, the plaintiffs want this settlement to be approved. B, the defendants want this settlement to be approved. And as far as we know it, the AG wants this settlement to be approved. So it's not circumventing Judge Hellerstein's order. It's going back to the drawing board, trying to rework this thing, trying to get it in a form that's going to be approved by the judge. Because again, in my opinion, and I know other people have echoed this, it's the best route for a recovery for those who have made claims against my client and the Weinstein Company.
Well, look, it's a tough decision and it's a tough subject matter. So there's really no easy answer, especially when you have these different interests and these different views on what a settlement should look like or what the proper avenue to recover would be. So again, we will follow what ultimately happens, but I'm glad that I got your perspective, Imran, on both of these big cases. When we come back, though, we have to talk about an update in the Tyrese Haspil case, the man accused of killing and dismembering his boss in New York City. Stay tuned.
Due to the active and ongoing investigation, I will not get into the actual cause of death. The extensive investigation led by the 7th Precinct Detective Squad, Manhattan South Homicide, identified the perpetrator in less than 3 days and revealed that Mr. Haspil was Mr. Salih's executive assistant and handled his finances and personal matters. It is also believed that he owed the victim a significant amount of money.
All right, let's talk about Tyrese Haspil, again, the personal assistant or former personal assistant who's accused of brutally murdering and chopping up the body of his boss, Fahim Salih. Really disturbing case, but now his girlfriend, who he's been dating for about 2 years, sat down with Spectrum News, a local news outlet in New York City, and she says that she believes that Mr. Haspil is innocent, that he's not a violent man, he couldn't have done this, and apparently she's still open to marrying him. She's telling everybody to keep an open mind here. Now, I'd like to turn to you, Terry. This is an interesting case. What do you make of her statements? Because there could be a question, is there really more to the story than he's the one who did this? Or is this somebody who maybe is in denial or is kept in secret about who Haspil really is?
I think she's absolutely in denial. I mean, look, we have some video, I guess, of him in the elevator, or at least we know that that's where he was before Salih was killed. And if in fact they end up having DNA evidence, they have a motive, I think she's going to have to ultimately face reality. And she probably does not know her fiance or her boyfriend as well as she thought she did. Many people always say, oh my gosh, they look like such a nice neighbor, such a nice person, until you find out that in fact they were involved in some heinous crime. And Jesse, this was one of the most heinous crimes that you could possibly commit.
Yeah, in New York City, in his luxury condo, just unbelievable to think about. Now, Terry, let me just stick with you for a second, because we learned something else, that this girlfriend was apparently interviewed by police, but she was ruled out as a suspect. In fact, her lawyer, H. Benjamin Perez, says, I just don't believe that there are going to be charges against her in any capacity. I don't think she knows anything about this homicide. Very interesting that police did question her about potential involvement. What do you make of that?
Well, you know what's even more interesting? The fact that she has a lawyer. So I think that if we ultimately have any sort of digital evidence, she could be tied in. Right now, just based on what we know and based on the reports, it doesn't seem like she was an accomplice or that she was conspiring with him to kill the boss to kill Salih. So we'll see what happens. But if they're going to tie her in, I think they're going to need more, at least circumstantial evidence to put her involved with this crime.
Imran, let me ask you this. Haspil's attorneys have said that police and prosecutors leaked information to the media, and that is one of the reasons why he's getting an unfair shake. They're saying that he's not getting proper due process. Everybody already has a negative view of him. That allegation, if that's true, what does that mean?
Well, if I was Haspil's attorneys, then when this thing came to a head and if it was going to trial, I would have to gather, or I would gather up all the reports or any evidence that I felt showed that he was unfairly portrayed in the media by the police, by the prosecution, and then try to move for a change of venue. Now, whether that was the case here, I live in New York City. I'm here in New York City, and I watched pretty intently the news coverage on this. I don't think that there was anything really improper that was, put out before the press by the prosecution or by the NYPD. I think this was a heinous crime. The public wanted to know what happened. An arrest was made very, very quickly after this crime, and the NYPD and the prosecution essentially let New York and the country know what happened. Or at least with this suspect and with this arrest. And I don't think there was anything really unfair put out in the media.
Well, it's an absolutely disturbing case. I think everybody can agree on that. And if we just move forward from this case to another eerie, chilling, and absolutely horrific case, I want to turn now to Connecticut, to the missing mom, Jennifer Dulos. You know, we've covered this here on Law and Crime. Fotis Dulos, her estranged husband, had been charged with her murder, but he died by an apparent suicide. His alleged accomplices, though, including his former girlfriend, Michele Trovonis, are still on the hook. And she is facing several charges, including conspiracy to commit murder. But now we are learning that her case has been pushed back to October. So what are her attorneys doing? Well, her defense team has been trying desperately to get a change of her release conditions, namely trying to get that ankle monitor off of her. And they said that they have several motions. They want this heard. Now the case is being pushed back without her consent, and now they are trying to appeal to a higher court. If you just think about her attorney for a second, the last time that we heard him speak publicly, or one of the last times, he had this to say.
Today was just about loosening the restrictions on her house arrest. We have postponed until March 20th consideration of any other motions that will be pending or are already pending. Perhaps that will be when we discuss the change of venue, that is moving the case to the Hartford Judicial District. Other than that, it was more of a first court appearance. Michele pled not guilty today on the most recent charges and asked for a jury. And until I've reviewed the material that were just given to me, and that's why I brought this large briefcase, I have no other comment because I don't know enough to say anything other than what I've said before. Michele is innocent of these charges, and we plan to fight them through the courts. Thank you very much.
Can you share any reaction to the death of Fotis Dulos from Mr. Troconis?
No, I would say that that's not appropriate.
Mr. Troconis, you want to...
Terry, let me start with you. This is an interesting development. The fact that her attorneys are saying, look, we want to appeal to the higher appeal court because her case was delayed. She never consented to that. She has issues that she needs to be heard by a court of law, and now it's getting postponed, including her trying to get the ankle monitor off. I mean, again, she was scheduled for a court appearance on August 6th. So is that a good argument? Do you think that there should be immediate relief for her? And I know a lot of people don't have a ton of sympathy for her, and they obviously have beliefs about her at this point. But is that a good legal argument?
I don't think so, Jesse. And I'm going to say what my law school professor used to say in this kind of case. Too bad, so sad. I mean, she's getting a delay, but who isn't getting a delay? This is COVID-19, and she can't be expected to be treated differently than other people and to get the monitor off. I mean, that's the least of her problems. So I definitely think that they are grasping at straws. I don't think that they're going to be able to get any additional relief here. And I think unless the trial is delayed, to 2021, and we've seen that, Jesse, so that's a distinct possibility. I think that the Troconis is going to have to deal with the slight delay from August to October until the court can resume session.
You sound just like the state attorney, had the same arguments that she doesn't deserve preferential treatment. I do want to ask you this, Imran. So her attorney said that the continued enforcement of these release conditions substantially interferes with their ability to provide a constitutional obligation to investigate the charges and prepare a defense with client assistance without the state watching every move. What do you think about that argument?
I don't think it's necessarily a compelling argument because defense attorneys prepare defenses, prepare a case with their client who are under certain release conditions such as ankle monitoring or house arrest all the time. It's not an uncommon occurrence. It happens all the time. In fact, a defense attorney should be happy and the client should be happy that they're actually in under ankle monitoring or in house arrest rather than in jail. A client in jail for a defense attorney is more of a hindrance to a proper ability to prepare defense because there's hurdles that they have to go through to meet with their client, to talk with their client. Here, I don't really see that as a compelling argument. An attorney can meet with their client, whether they're in the home or under ankle monitoring and going to their office. And often when they have an ankle monitor, they are allowed to go from their house to their attorney's law office. So I don't think it's a compelling argument.
And let's not forget, Michele Trovonis is charged and implicated in being a part of all of this. You know, Jennifer Doulos' body may not have been recovered, but authorities believe that she was a victim of a violent attack, and they believe Troconis was a part of helping to dispose of the evidence, whether it was washing the car or actually disposing items. You know, she was allegedly a part of this whole thing. So that's a huge, huge allegation here, and we have to think about that. If she's out, she is maybe having a different kind of treatment than other people in her position. Now, listen, we have to take a break. When we come back, a lot to talk about because Ahmaud Arbery and Johnny Depp, big news in both those cases. Stay tuned.
As indicted, he's facing not just 18 months that speculatively he might be held upon prior to trial. By my calculations, he's facing potentially life without the possibility of parole, plus at least 27 and a half years. That's a significant amount of time and the most serious charge that could be levied against the defendant in the state of Georgia. There are texts to support the DOJ's investigation. I've revealed this to Mr. Goff, and he knows that we talked about it on the phone. I can confirm as of yesterday that the GBI has opened an additional parallel investigation into sex crimes.
And that investigation seems to be about child sex abuse. Yeah, that's right. William Bryan, one of the men who's been charged and accused of murdering Ahmaud Arbery, we found out he is apparently being investigated by the GBI for an allegation of child molestation. Now, we don't have a ton of details here. It was actually first recorded by First Coast News. But what we seem to gather is that this is a white female, and an incident had taken place in Camden County. Terry, what a revelation this is. So in the bond hearing, and his bail was ultimately denied, one of the reasons is that it was being investigated here. We knew it was a sex crimes investigation, but now we're finding out this about child sex abuse. How could that factor in to his current case in the Ahmaud Arbery trial?
Well, Jesse, it's such a different type of crime. I don't think it'll ever get into evidence here. I mean, you can use prior bad acts, but it's not even a prior bad act yet. It's just an accusation. So I don't think it can get in, and it can't get in to show his propensity to commit this type of crime because clearly that's against Rule 404. It could be used, I suppose, to show a motive, but it's so different from what we have in the Ahmaud Arbery case. So I think as far as the trial is concerned, we're not going to see it, but it could be used, I think, to leverage the case. And in fact, maybe they could get Brian to testify against the other two, the McMichaels, because they have this other allegation that they could use as leverage against them.
We usually agree, but I have to disagree with you here. And Imran, I'd like for you to give me the perspective on this, because usually, you know, if we had a situation like the college admission scandal, right? You have somebody who's charged with a certain crime, they're not playing ball. We got this larger crime, this more serious crime in our back pocket to charge you with unless you play ball, maybe unless you testify. Here, he's facing a murder charge. Does it get any higher than that? So if you hit him with a sex crimes violation, again, serious charge, but how could that be used as a bargaining chip to say, hey, listen, we won't hit you with this, or we won't charge you with this, or we'll drop the charge here if you agree to testify against the McMichaels? I mean, how could this revelation, and we're talking a little premature here at this point, but let's say he is charged with some sexual assault of a minor, how could that be used as a bargaining chip?
Well, Jesse, I'm actually going to disagree with you, and I'm going to agree with Terry on this, because with this cooperation on the murder case, that's one thing, right? They can offer him a better deal on that case specifically in order to gain his cooperation. But now they also have this other possible charge, a separate action that he would be facing. And they can use that as leverage, because now he's not only looking at the charges, yes, the most serious charge of murder on this case, but then he's also facing this other possible prosecution, and then facing one charge in one case and a separate charge, especially with allegations as so heinous as child molestation. It definitely can be used as leverage to gain his cooperation on the murder case.
See, I'm torn. I can agree with both of you, but I also disagree, because there's a situation, this case has brought so much attention, there's so much emotion, there's so much a political angle to it as well, that to say, hey, William Bryant, who is apparently an integral part of what happened to Ahmaud Arbery, to say we might drop a charge here, or we might give you some leniency in this case with such a heavy allegation, heavy crime in a separate kind of incident, I don't know how people would react. I don't know how the community would react. And look, that's just my opinion. I could be 100% wrong. You guys are the experts here. But here's the interesting thing to think about this case. There is a human element. So let's go back to Ahmaud Arbery's mother, who actually spoke about it during the bail hearing, who William Bryant is and why he should be denied bail, and what this case means to her.
I often visit the location where my son was killed. And each time I visit there, I fear running into all the three of the men that murdered my son. Because William Bryant does not feel he did anything wrong. What is it to say to stop him from doing this again? He must remain in custody. He's dangerous, he's unapologetic, and therefore I'm asking this court to keep him behind bars.
So again, not an easy case. All right, I want to wrap up our show with a case that we have been following, and this is the celebrity angle. Let's go to the UK for Johnny Depp, because his libel trial against the publisher of The Sun and his executive editor has come to a close with really a dramatic closing argument by his attorney, as well as a statement from his ex-wife, Amber Heard. Now, you might recall that Depp is suing in regards to a 2018 article that claims he falsely labeled him a wife-beater who attacked Heard. Now, what was interesting, Terry, is that his team had said that the purpose of this lawsuit was to clear his name, to clear his reputation, and that he shouldn't be in the same vein as Harvey Weinstein. But that's interesting considering everything else that came out during the course of this trial. Did this case ultimately help his reputation? Because there were allegations of, not even allegations, accounts of serious drug abuse. You saw the profane text messages, really bad fights. What do you think about that statement from his attorney in the closing argument?
Listen, I don't think it was worth bringing this lawsuit either against The Sun, and there's another lawsuit that Johnny Depp brought against Heard, and I guess that will be coming up in the future. He wants to clear his name, but in so doing, there's a trial that puts out all of this information about their sordid affairs. So I don't think it was
and that's something that I don't know if a lot of people think about before they go file a lawsuit. Obviously, they're told by their lawyers this might all come out, but to see it actually happen is another thing. Now, Imran, I know we're running out of time, but you know, Terry mentioned the $50 million defamation lawsuit that he has filed against Amber Heard in the United States. If the NGN, News Group Newspapers, loses this and Depp wins, and clearly that means that Amber Heard's story wasn't true or the court doubted it, how would that affect the case in the U.S. and how would that affect her career and reputation?
Well, listen, there's what's interesting about UK libel law is that the burden is different than U.S. law. So a finding in the UK case will ultimately have bearing on the US case because it's such a public event. But
Yeah.
I think that it will have bearing on both their careers. No matter how the court rules in the UK or the US, I think both their careers are going to be affected by this. They brought a lot of ugly news into light.
We got a sequel to Aquaman and a potential continuance of the Pirates of the Caribbean franchise. So there's a lot weighing here. Imran, Terry, thank you so much for coming on. Appreciate it, everyone. Have a great night. We'll see you next time.